All right. Well, let's go ahead and get started. Again, Mike is going to be here on Wednesday, and please have some questions for him. This chapter is just made for Mike's visit because it really gets into search seizure scenarios that we can give him. The difference between a reasonable suspicion and probable cause. There's just all kinds of good stuff that we can tap his brain on. Search and seizure. Search is where we call them LEOs, law enforcement officers. When LEOs will intrude on a person's reasonable expectation of privacy. Now let me ask y'all something. Is Facebook covered by search on that?
No.
Would that be affected, Facebook?
No.
Depends on the settings. If you have public and anybody, you've got it where anybody can look at your Facebook page, there's not an expectation of privacy there. But if you have it on private, then you have put up a block there, and the police might be very well required to get a search warrant to look at your Facebook page. And so it really depends, we can talk to Mike about that, but I think I'm correct on that, because you have a reasonable expectation of privacy if you put that as a private setting. Now, what about cell phones?
Yeah, but they lock.
The what?
I say, yeah, they lock.
What if they're not locked?
Still personal property, isn't it?
It's personal property.
I'm thinking you need a warrant for it, but
You're right. There was a case that went to the United States Supreme Court, and I just have it here. Let's see here. Well, I did have it marked. We'll come up to it in a minute. A police officer has to get a search warrant to search your phone for information. Now, they don't if you tell them it's okay, if you hand it to them. Now, we had a case earlier this year where there was a death of a minor, and the police asked the parents if they could have the phone and look through the phone for information, and the parents gave them permission. So they didn't need a warrant then, but to look through a cell phone, you have to have a warrant or permission. Reasonable expectation of privacy, what does that mean?
People expect it's private.
What would an average person expect on privacy? And you get somebody who's extremely paranoid and that they're so secretive, that their family doesn't even know what's going on. That's not a reasonable situation. And so what a reasonable, average type person would expect on their privacy. A seizure, this is use of authority to deprive someone of liberty or property. A seizure is an arrest. A seizure can also be acquiring evidence for a case, okay? Now, a stop is where a person has a brief detainment and the police officer must have reasonable suspicion to stop them. Okay? Now, anybody got a real good example, real quick, of a stop?
Pulling somebody over.
That's exactly right, a traffic stop. You don't expect, when you are stopped in traffic, to be detained hours and hours and hours. You really expect it to be pretty brief. They'll tell you what you did wrong. They'll either give you a little talking to, or a warning, or a ticket, and then you're on your way. Now, there's what's called the plain view doctrine. If something is within plain view of an officer, when they enter a house, if they stop the car and they see something in the car that they don't have to reach in and look under or something like that, it's just sitting there in plain view, then that permits the officer to use that as evidence and to move to probable cause to an arrest. So, the cops come in, they are, they're wanting to know if John Smith still lives in this house. And you say, no, he hasn't been here for several months. And they said, well, would you let us come in and look? Okay? And when they come in and they look around, and on the kitchen table, there's some white powder cut into some lines. Do they have the authority then to move in on that?
Yeah.
Yeah.
Absolutely. Absolutely, because that is in plain view. They've been given permission to come into the house. As they were searching for this guy, they see this white powder. And so therefore, plain view says they have the right then to move in and go ahead and start the procedures for arrest in that home concerning those drugs. There's also called the plain smell doctrine. What would you think that would be? If you can smell something that would seem illegal. This usually pertains to drugs. And so, pulls a car over and it smells like marijuana. He has the right then to look further into the car and see if it's there. Okay? A cop is having to deliver a warrant to another house, and he starts smelling crack, the manufacturer of methamphetamine. And so he smells it, and it seems to be coming from the next house. What do you think he needs to do?
Go to the next house?
Do what?
Go to the next house and knock.
Look for,
I say go to the next house and knock.
he could do that, and ask if he can come in. Okay? We'll have to ask Mike, but I think that to actually go further, he'd probably have to have a warrant to enter that house. We'll have to ask Mike, because the plain smell doctrine, I think pretty well covers something that could be more mobile, or, that it could move quickly as evidence. One of the things about a warrant is extremely specific. I mean, letter specific. And so, the warrant will say, we are looking for such and such, drugs, at such and such an address. Last known tenant was such and such, an individual, and, they will specify every little thing, all right? So, they say, we've got a farm area, okay? And this farm area, they get the warrant for the house, and they don't find anything in the house, but they see a barn, and they go over to the barn and they find a whole stash of drugs. Are they okay?
No, because it wasn't on the warrant.
That's not on the warrant. And so that case would be kicked out because they went farther than what the warrant had said. And so they'd be SOL with that one. Anything that they would find in that barn would be called fruit of the poisonous tree. And so let's say that, these drugs also led them to evidence about a murder. That too would have to be thrown out because they got the lead because of an illegal search, and anything that results from that illegal search has to be thrown out. And so fruit of the poisonous tree is something that's very, very critical. The use of force and the Fourth Amendment. Tennessee versus Garner, very important case. 1985, police may not use deadly force in apprehending a fleeing felon unless they have to keep the suspect from escaping the office, and the officer has probable cause that the suspect poses a significant threat to him or other people. So, a guy does a crime and he's running away, the guy has slipped a note to a bank teller and says, I've got dynamite all over my stomach, and if you don't load up this bag with money, I'm going to set the bomb off. So they load it up with money. Unbeknownst to the man, they hit the alarm button. As he's coming out, he sees a cop car driving up, and he starts running. Now, he's running and he's running and he's running, and they say, we can't catch him. Now, all we know is that this guy has robbed the bank. They don't know anything else except a bank robbery has taken place. Would they have the right to shoot him to keep him from fleeing?
No, because they don't know that he has a bomb, so no, because they don't know that he's a threat.
They do not know if he's a threat of death or a serious injury to anybody else. Okay? Probable cause is what gives that's basically the final thing that gives the officer the ability to arrest somebody and charge them. Okay? We have another case then, and this one's kind of to me, I don't want to say it's squirrely, but it kind of stirs the mud up for me. All right, the Graham case said that police can use force. In fact, let's see here. The use of force, any force, should be judged from the point of view from the officer. And so what the Graham Act said is the officer can use any amount of force necessary by his perspective. Anybody got a problem from that? Nobody has a problem with that?
Well, if you don't have all the facts,
Don't need all the facts. It just says whatever the, officer thinks is necessary, do it. He's the one that determines how much force is necessary.
I think it would be somewhat problematic, like for others, like if they wanted to sue the police, or it could be the suspect. It could be somewhat problematic because different officers may have different morals, and so someone can make the argument for the case that what they deem necessary should be based off of a moral code or an ethical code within the police force itself.
I don't realize how much training goes into use of force. There's a lot. Let me mention 2 words and let's talk about this, because I think we'll probably get something stirred up with this. How about George Floyd? Now, the officer put his knee on the guy's neck, and the guy is screaming, I can't breathe, and he ends up dying. Now, what are y'all's thoughts?
Well, I don't remember all the facts or anything from that, but from what I have read, what I think I know, which could be false, that he was already like high on some sort of drugs that was impairing his breathing already. Granted, standing, putting his knee on his neck did not help, more than likely, but part of it was his own fault because of that. And like I saw like the whole video where it took a lot of him to get him down. He wasn't complying with them either, and so he wasn't complying, and he was high on drugs. I don't know what kind of drugs that could have made him stronger, or they don't know how he would have reacted, so they needed to pin him down. But still shouldn't have died in the first place. But at that point, it may have been necessary to do so.
Well, basically what I gave you was what the news media gave us. He was arrested, thrown down to the ground, a knee put on his neck, on his neck. He's screaming, I can't breathe, and he dies. The rest of the story is just like you said. First of all, the man had a record, and on something like that, if the police officers are given that information, that already tunes them up to a higher level of adrenaline. When they came to him, he was already complaining of he couldn't breathe. He had a load of different drugs inside of him that was complicating the respiratory problems that he had. And then the drugs caused him, when he did not comply, to have multiple officers take him down. When they started to put him in the car, again he resisted, and that's when it was on again. Now, the thing that is to be noted is, first of all, the officer should have probably put his knee on the guy's back and not the neck. That was out of compliance with what we've been trained. That's not good technique, and we got a problem there. We got a problem with other officers standing by and watching that. If he was having problems with them complying, they should have had more officers down there subduing it. Also, if I'm not mistaken, those two had a history with each other, so that complicates the mix. So it's not cut and dried that the guy just killed George Floyd. There are a lot of facts that have come to light since then, including the autopsy that said that the knee on the neck did not kill the guy. he did not die of aspiration from the knee on the neck. And so, those are things, you know, when we hear these things, we need to wait for all the facts to come out and then decide what's going on. Because that George Floyd case has ballooned up into a mess. When you are stopped in a, when you are stopped in a traffic stop and the cop says, "I smell marijuana. Would you let me look in your car?" And you say, "No, sir." He said, "Okay, well, I'm gonna get me a drug dog." Is that legal?
Yeah.
Sure is.
Don't make the weight.
But the problem is, the Supreme Court has ruled that you cannot be detained an unusual amount of time. So basically, the officer has about 30 minutes to get another officer with the drug dog over there to check the car out. You know, always something there.
So what if you get to that 30 limit mark? Can you just leave, or?
Well, I would say that the first thing I would say is, quite frankly, according to such and such a ruling of the Supreme Court, I really should not be detained any farther. And if I am, I would like the opportunity to go ahead and start calling my lawyer. And that would probably put enough fear into the officer to let you go. Because when you start quoting Supreme Court case about unusually long detainment, and then start talking about your lawyer, and he probably doesn't know how much longer it's gonna take that dog to get there, then he's on notice at that point that you want legal representation. And so that would be something that he would have to certainly listen to, and it would probably be enough to make him let you go. I like that question. Anything else? Still looking for that cell phone now. It was Rodriguez versus the United States that you cannot hold a person longer than a reasonable time for stopping.
Did you know, in one of your tests, the questions are kind of like,
Yeah, you weren't here when I talked about that. I think it's the unit test that has 10 answers incorrect, and I'm adjusting the grades for those. All right. Okay. Speaking of search and seizure, let's just say that a cop is at a 7-Eleven store, and he comes out and just wants to talk to you. Is that okay?
Yeah.
Okay. Is it okay if he wants to chit chat and ask you where you've been?
Depends on what it is.
We may be getting into some gray territory there, because just coming out of a 7-Eleven and just picking you out and saying, "Hey, where you been?" He's gonna have to have reasonable suspicion that you've been involved in a crime before he can do, start to investigating further on that. Okay, to arrest a suspect and take him into custody, the police need what's called probable cause. This shows that sufficient evidence exists to make it likely that the suspect committed the crime. Okay? So not only do you have a really, really good solid suspicion this is the person, but you've got evidence to back it up. Okay? Now, a warrant. For a warrant to be issued, there has to be probable cause. And the judge is gonna be really ticky about that. He'll wanna know exactly what the probable cause is before he puts his name to that warrant. The probable cause is going to be determined by the totality of the circumstances. The warrant, it says it's an affirmation by affidavit, particular description there. And so we talked about that. Warrantless searches. There are certain times you don't have to have a warrant. What would be an example of not needing a warrant to search somebody?
In an airport?
In an airport. Mm-hmm. We get searched all the time when we go through the airport. First of all, you go through that metal detector. And if you cause the thing to beep, then they can search you even closer. Okay? Another warrantless search, sobriety checkpoints. Now, let me tell you a little something about those. They have very, very, very specific regulations that they have to follow on that. Those have really gone through the courts. And like, I was working in one, and ahead of time, they said, okay, what we're going to do is we're going to search every third car. We weren't allowed to search every car. You'd have to make a determination, and then if you just hit that right and you got somebody, great. The only exception was when this guy drove up. He drove up 4 flat tires and, all over the road, and there was no doubt that he was inebriated, and he was stopped, and he was arrested for DWI. But that was because he showed evidence of intoxication. It wasn't that we just picked him out of a line and said, okay, this guy is going to, he's going to be one of the ones we check. You have a specific designation, and the cops have to abide by that. Now, stop and frisk. Terry versus Ohio. This says that an officer has the right to protect himself if he stops somebody to make sure they don't have a weapon that they can hurt him. It makes sense, doesn't it? I mean, he wants to go home to his family that night. And so, when he stops somebody, he doesn't know if there's any possibility that they have any weapons on them. You weren't here last week. Were you all here when I showed those videos? I know you were. I don't think either one of y'all were. I know you were.
I wasn't here Wednesday.
Let me show y'all something.
What all work do we use for your midterm grade?
You need to have done all of the first unit, which are the first 3 chapters.
Just the first 3?
Mm-hmm. I think this is it. No, this isn't it. Where'd it go? Here it is. you to look at this. This is what cops deal with.
You have audio?
Ryder, come back here with me. Come on back here for me. Come on back. How you doing today? Good. Come on back here, keep your hands out of your pockets. Keep your hands out of your pockets, sir. Sir. Come here. Sir, come here. 37 Reyes, 78. Come here. Sir, get back. Sir, get back. Now, get back. Get back. Sir, get back now. No. Get back. Sir, get back. I said now. Get back, sir. Sir, get back. Sir, get back. Get back. Get back. And I am not. Sir, get back now. Get back. Get back. Get back now. It's in there, 18. Sir, get back now. Sir, get back now. Sir, get back. Get out of the car now. Sir, get out of the car. I am being my life. Get back here now. Take the lead of the vehicle. Take the gun down. Well, I got down the gun. I need help. Put the gun down. Put it down now.
He should have shot him long ago.
Put the gun down.
When you started walking up to him.
Drop the gun now. Stop now.
What is it, dead? What was he dead?
He died. That particular thing is used in training films, or training all over the United States for cops. But, now, that guy had a rifle, and he came out of his car and went back and got the rifle. But, you know, like, right now, I'm carrying a switchblade. Well, it's an automatic knife. It doesn't take that long to pull that out. And a knife is really, really dangerous to a police officer in close quarters. They say within 20 feet, a knife is probably more dangerous than a gun, because by the time if somebody's running at you with a knife, by the time that you draw and fire, they're already on you. And so, yes, cops need the ability to frisk somebody to make sure their safety is okay. Now, a Terry frisk is different than an arrest frisk. A Terry frisk, basically they teach us to do it with the back of your hand and just feel and see if there's anything that feels like a weapon. And if there is, then you go ahead and tell them, you know, to please empty their pockets or whatever, or give you the weapon. Search incident to a lawful arrest. This allows a weapon search during an arrest. So now that you've arrested them, you can go ahead and pat them down completely. Now, the way we were taught to start, you go and you do the arms and you come right down, up the legs, back the shoulders, in the waistband, front, have them take off their shoes and see if there's anything in their shoes, their hats. I mean, it should be a complete search, but cops get lazy.
Could that be mistaken as sexual harassment?
Not if you have a female on female or male on male, unless they do something very inappropriate. Now, a male officer can do a Terry frisk of a female.
But not a normal?
He's allowed to, but everybody tries to avoid it just because you don't want anybody screaming sexual harassment. That's why if a cop anticipates he's gonna be arresting a female, he'll already get a female officer en route.
Gotcha.
And he'll try and have somebody there very quickly to help him with that because, it's very, very litigious society right now, and people are looking for every chance they can to sue somebody. Now, what was I gonna say? There was something about the frisk. Well, hopefully I'll remember it again. But there's so much to you're constantly thinking about your safety. If you're not, those are the ones that really, really get hurt. I know what I was gonna tell you. If, say, a male has to transport a female, there's no female officer available, then when he starts out, he calls into dispatch, here's my mileage, here's the time I'm leaving for the jail. And then, as soon as he gets to the jail, here's my mileage, here's my time in. That's to cover him for being accused of any unexpected stops. Okay? You have the right to protect yourself. And searching for a weapon, especially when you've arrested somebody, you have the right to make sure they don't have something in there that they're going to hurt you with. Now, after a person's arrested, even after they've been frisked, many of the officers will check their cars after they've taken the suspect in and booked them, and make sure that they didn't miss something and some evidence has been put in their car. For many, that's SOP. But if it isn't, it should be. All right, let's see here. Got 10 more minutes. Exigent circumstances. All right, a warrantless search says that if there's an immediate threat to public safety or to evidence, that they can seize it without a warrant. Okay, so traffic stop, and the cop discovers a brick of marijuana. Okay, he doesn't have to call and get a search warrant to search that car for that, I mean, to take that evidence. Especially, let's say that it's plain view. You certainly don't have to have a warrant for that. But let's say that, I'm trying to think of a good example. I wonder if your book has one. I don't see that right here, so I'll get back to that on Wednesday, or we can talk to Mike about that. I do want to cover Miranda before Mike comes. I see something very often that needs to be addressed. I saw YouTube the other day, and this woman was detained, and she was not arrested, but she was detained. She became aggressive, and she was put in cuffs. Okay, she was still not arrested. She was not arrested. She was just put in cuffs. Well, it wasn't very long before she started screaming, "You screwed up now, you screwed up now, you didn't Mirandize me. You didn't Mirandize me." Okay, did he screw up?
No,
Why?
because he still hasn't arrested him.
That's right. When an investigation starts, that's one thing, but even with that, a person does not have to be Mirandized until they're arrested. And so, but even, all right, they've been arrested and they haven't been Mirandized and they say, "I want a lawyer," what's that mean?
They know their law.
Okay, what else?
It may remind the officer to do it, that they don't have an excuse. So-
Definitely that, but
They don't have to answer.
even if he hasn't Mirandized them, if they say, "I want a lawyer," that cop should basically do nothing else but Mirandize them and say nothing else. When they start claiming lawyer, there is not one question that should be asked that person, pertaining to the case. Of course, you can say, "Do you want Coca-Cola or something?" But if it's pertaining to the case, absolutely nothing should be talked about. Now, if they haven't arrested you, then it's perfectly okay for them to talk to you. And, all right, they're gathering information, and they're trying to figure out exactly what's going on, and they say, you were in this area and this happened. Do you know anything that was going on? Do you have any idea who did this? That's okay. That's okay, even if they're the person who did it. Because when they're just trying to get the information, they can ask those questions, and it's perfectly all right. Now, here we're talking, there's one thing there about an automobile search and inventory. That's kind of an interesting thing. It is a warrantless search. This is used often if a person is arrested and their car is going to be impounded. The police officer has a right to go through that car to make a list of everything that's in that car, and especially like if she has her purse there, to go ahead and make sure there's no evidence in the purse, but go ahead and take the purse with him as part of her belongings. But if he finds something in that inventory, it's good. So, he's pulled somebody over, they become belligerent, they get out and they take a swing at him, and he arrests them, and he has the car towed, he inventories the car, and he finds the whole trunk is filled with all kinds of drugs, drug paraphernalia, drugs, measuring, like the balance scales and such, he's got them. He's got them, because during an inventory, if they find something, they can use it. Okay? Well, it looks like we are at the end of this class. If you will, please, make questions, bring questions for Mike. He said he'd try and find another case, but he's really wanting to have specific questions about, police work, so that, he can help explain some of that stuff too. Okay? All righty, y'all.
I have a question for you.
Yeah, if you will, please make sure you get the little, wipes, and, you'll, sanitize your area.